She said, I think she was looking directly at Krenwinkel. I think she said, "How could you have done such a terrible thing?" This was said when the girls were looking at her. I think it's obvious now that the defense has given up trying to break her story from the standpoint of veracity. By handing her these dreadful, dreadful pictures, I think they're attempting to wear her down to the point where she cannot continue to testify and in that way create some kind of mistrial or some problem in the case. It's clear to everyone after 6 days of cross-examination that there's no way to break the girl's story. She's truthful. Now they're trying to break her spirit.
What are you telling her during the recesses and the time off? How are you keeping her spirits up?
We say nothing about the case to her. We're both very close to Linda. I've personally spent hundreds of hours with her, and I simply try and discuss things about what will happen when she gets out of custody. We have a friend of hers here now from New Mexico, a dear friend, who is here to give her strength because of the peacefulness of his ways, and I think he will.
We share the same spirit. Spiritually, we're brother and sister.
Where did you meet and stay together?
I don't want to answer that.
Can you say how long he's known her? He said 3 years.
They're dear and old friends.
Can you tell me how long or when the last time was that he knew Linda or saw Linda?
I'd rather not talk about it.
Wait a minute, Mr. Fleischman, he made a comment to me earlier in court when we first spoke, and no, I'm not going to hold that against you, but if he's not going to be a witness, then why can't he reflect on what he has heard Linda say? Because he has apparently heard the story before.
I
know. Spiritually?
Were you ever, did you ever spend any time at the Spahn Ranch?
No.
Know any of the persons or members of Charlie's so-called family? Are
do
you
you
a
think
friend of Robert's, Kasabian, Linda's husband?
Yep, he's my brother.
He's your brother. You mean real brother? Spiritual brother?
Blood brother too. He's your blood. I know, Gary, he's my real good brother. He's my good brother.
How do you think you can be of help to Linda?
Just giving her strength, someone she can relate to. Someone she can focus her energies on and get energy from.
She's been on the witness stand now 9.5 days. And to have a friend nearby and a friend who feels like her brother, maybe he is her brother, is a great deal of comfort to her, in my judgment. They were all her brothers.
Has she looked at you?
Yeah.
What kind of vibrations, if I can use that word, have you got from her?
She's tired and she's looking for strength.
Are you afraid of Charlie?
No.
Why? If you think he's the devil?
Because the Lord, he's stronger than the devil. Lord is stronger than the devil. I'm just a messenger of Jesus Christ. I just walk in this earth peacefully, and I know my peace is going to tear down any child of Manson and any bad things he's going to got going.
Even if he's the devil?
Yeah, he's the devil. But the Lord, he's stronger than the devil.
Do you think that Charlie, as it is said, practiced witchcraft?
Yeah, well, he practices just in his general life. Everything that he had, all these chicks on his trip and everything. That's witchcraft. That's using that black magic.
Do you feel anything spiritually from Manson?
What do you mean all the chicks on the strip?
He got a lot of chicks on the
Thank you.
Boy counselor.
That's perfectly all right. Interview with Irving Larry.
Twice again this morning, Linda broke down At one point, she looked at the 3 female co-defendants and said, "How could you do it?" after you had shown her a photo of one of the murdered persons of the Tate Mansion. Is your cross-examination directed toward making her an accomplice in this case? Or how does it fit with the overall defense?
Well, of course, because of the publicity order, Judge Keene and Judge Older, I can't state what I can't answer your statement directly. I can only say that I would your view of the situation is certainly one that you're entitled to make, and perhaps you can be more objective about it than I could.
Mm-hmm. Now, I believe that I'm sure the jury did not see those photos, but I saw at least one of them, which was obviously a photo of Abigail Folger in her white gown, to which Linda has testified seeing. Am I correct in assuming that it was a photograph of Gibby Folger?
Well, again, you'll have to make your inferences from what you may know. I can only say that the deduction that you care to make with what you may know about the case is one that, knowing your ability for analysis and your ability to, as a newsman, to absorb detail, I would say I would invite you to make the analysis.
One final question. Would you say my eyesight is 20/20?
Well, I just can't answer that one either.
Thank you, Ernest.
Mr. Konerik, you're getting a lot of criticism for showing these photos to the witness. How do you feel about this tactic? Do you feel it is proper?
Well, all I can say is that we are in a courtroom where there is a very capable judge, and certainly what is going on in that courtroom is under the jurisdiction of the court. And everything that we do in any case, I hope, is what is proper. Because a particular witness or the other side has a particular point of view does not mean that the side adverse must adopt the point of view of a particular witness or the other side.
These photos. Go ahead.
Mr. Konerik, you seem to be following the line of questioning that Mrs. Kasabian was inside the home and somehow was physically implicated in the killing. Can you elaborate on that?
Well, regrettably, because of the publicity order, I cannot elaborate on it. However, what has occurred in open court, and you men who are sophisticated members of the media certainly can make your analyses. All of what has occurred in open court, and actually your viewpoint is probably much more valuable than mine, because in many ways you people, not being lawyers, have a state of mind which may approach that of a juror.
But you seem to be saying that she was inside the house.
Well, what I'm saying is you certainly you're entitled to make your inference, and since it has happened in open court, that's the beauty of one of the beauties of a public trial, is that. Well, in this, I don't.
You're on the tube, I'm not, so why don't you do your thing?
Well, I appreciate it.
Let's trade places.
I don't want to crowd you guys out all the time.
I just need the sound.
Oh, sure.
You're a full reporter.
Yeah.
Mr. Goldman, do you think the testimony of your witness has been cemented by the events in court this morning?
I certainly do. I think that she has repeatedly shown her veracity and truthfulness by this cross-examination that's been going on. The pictures he's shown to her have done nothing more than prove, as far as I'm concerned, that she has told nothing but the truth throughout these proceedings.
In what respect do you say that? I mean, what do you mean by that?
Well, it's clear that she has not ever been inside any of the residences where these murders took place. She was able to identify, nevertheless, the persons whom she did see, or at least the white gown of Abigail Folger, and she was able to identify Frykowski, although she didn't know him by name. She does not know anything that happened on the inside of those residences. She's made that clear. Even though those photographs are very shocking to her, even though they are gruesome, nevertheless, notwithstanding all of that strain, she's been very able to continue to keep her composure and tell the truth.
She muttered something
I think it's
to the
obvious.
defendant.
Told her, and that she shrugged with a smile on his face, if I could characterize the smile. And of course, she realized that this was a very disconcerting thing where there was no expression of emotion or shock on their faces that she would be exhibited this kind of thing.
Yesterday, while she was seated at the counsel table,
Charlie's gesture.
Well, when Mrs. Kasabian was exhibited the gruesome photograph of Miss Tate, she did manage to glance over to Charlie, and she saw him give a shrug with a sort of a smile on his face.
he did more than that yesterday. While I was seated next to her, he put his hand across his throat like that. I don't know what he meant, but neither of us particularly cared for it.
One further question. You characterize the photos as gruesome and shocking. Do you think it's improper to hold them up the way it was done?
I have made an argument to the court that, of course, if he has a relevant or material question to ask concerning these photographs, the law gives him that opportunity. But he has no right to hold these photographs up in front of her, continue to force them upon her, or to hold those photographs. This is improper courtroom tactics, and I have asked the judge, and I think this morning the judge has complied with my request to stop him from employing those tactics.
One last question. Do you think a mistrial is inevitable as far as the defense is concerned?
Well, I don't think it's inevitable, but I think that that's probably one of the things they're working for.
Thank you.
Yeah, completely unrelated. All right, what do we do now? What do we do?
Hello to Gladys Root.
How we roll, Rick?
Paul, is Canary attempting to show that Linda Kasabian planted a wallet which was stolen, obviously, from Harold True, planted it in a service station, and later went back and retrieved it and used the credit cards for her trip to New Mexico? Is that what's trying to be done?
Yes, I think that's a fair statement. I think that he is attempting to establish, and I think he's well on his way to establishing, that Harold True was known to Linda Kasabian, and the state of the evidence is at the present time that she was not known to any of the defendants. That Linda Kasabian was driving the car on the night of August the 9th, and she drove the vehicle, she says, to the vicinity of Harold True's residence. She has also admitted that she took some change from a wallet belonging to one of the victims, Rosemary LaBianca, and secreted it within a restroom at a public service station, and that she did so with the intent to hide it. Now, there has also been a line of questioning concerning whether she returned and used the credit cards. Because recall that she had testified earlier that she used other persons' credit cards in order to finance her trip from Los Angeles to New Mexico at a later date, approximately the end of August 1969. And Mr. Kenerick is suggesting that the credit cards secreted in the restroom were in fact the credit cards she used to finance her trip.
Mr. Fitzgerald, of what value is it to the defense if you show that Mrs. Kasabian is an accomplice?
Well, the law in the state of California requires that a person cannot be convicted upon the testimony of an accomplice standing alone. An accomplice's testimony must be treated with caution. It is suspicious testimony for obvious reasons. In this case, it's suspicious because somebody is being granted immunity from 7 counts of murder in order to testify. Consequently, the law requires that an accomplice's testimony be corroborated, that is, supported by other evidence. And if Mrs. Kasabian is an accomplice, these defendants cannot be convicted on her word alone. There must be other substantial evidence, independent substantial evidence, indicating that they were connected with the commission of the offenses.
How will the decision be made whether or not she is indeed an accomplice?
The judge will first make a decision whether or not, as a matter of law, she is or is not an accomplice. If there is any doubt in the judge's mind as to her status, he will allow the jury to decide whether or not she's an accomplice. The jury will likely be instructed that if they find that they must first determine if she is an accomplice, and if they do find that she's an accomplice, they must then determine whether there is sufficient supporting evidence to indicate independently the defendants had some connection with the offense.
The fact that she chose the location in which to put the wallet in the gas station, is that sufficient evidence to indicate that she is indeed an accomplice?
I don't think standing alone that would be sufficient, Mr. George, but I think that the totality of her involvement, her alleged involvement in both Tate and LaBianca, and her so-called responsibility, and the fact that she went back the next night, and the fact that she assisted, and the fact that she drove the car and prepared the weapons and disposed of the weapons and didn't scream, didn't run, didn't hide, didn't call the police, would seem to indicate quite clearly that if what she says is true, she is an accomplice.
Is that then the thrust of the defense?
Well, I think that's obviously a partial thrust. That's one of the major issues in this case. Of course, on the other hand, and perhaps this doesn't make much sense, but on the other hand, we are first most earnestly contending that her story is fantasy, that it didn't occur.
Well, if you're
in the alternative, we're claiming that if the jury believes it is true, that she is an accomplice, and therefore her testimony must be corroborated.
So one of two ways: either your clients are innocent of anything connected with these things, or she is an accomplice to what did take place.
Yes, we contend that her statement is fantasy and that she wasn't there and that she's making this story up. If, on the other hand, the jury believes that she is there, we're attempting to establish that she was an accomplice, and therefore her testimony must be corroborated and substantiated.
Do you go so far as Mr. Kanarek did this morning to imply that she is unable to answer certain questions immediately because she can only answer those where she's been coached by the prosecution?
Implicating other individuals in this crime.
Yes, we will come up. We hope to produce evidence to that effect, but I'm not allowed to comment on it at this time. And I've been instructed by the court, particularly in regard to evidence connecting other persons with the commission of the offense, that the matter is not to be discussed or disseminated publicly until the court has actually ruled on the admissibility of such evidence.
Is there sufficient evidence in order to set processes in motion in order to apprehend suspects?
Well, that's a very difficult question to answer, because obviously the prosecution thinks that the right people are on trial. We not only have to convince the jury, I suppose, but in order to get people arrested, we would have to convince both the district attorney's office and the police department, and that might be a difficult task. We'd be satisfied with convincing the jury.
Thanks, Paul.
Is there some contradiction in the two lines of defense that either this is a fantasy, or if the jury believes that she was present, that she is in fact an accomplice?
Oh, I don't think that. I don't think there's necessarily a contradiction. I think that we're simply attempting to cover all the bases. I mean, arguably they're mutually exclusive in a logical sense.
That's it. That's good. That's the best one.
This is
Oh, thanks, kiddo. Whoops. Yep. Yes, I'll do that. Two questions. Is Linda Kasabian first a liar, and is she also an accomplice to the murders?
Well, I'd like to answer the question in this context. Whether or not Linda Kasabian is this or that or the other thing is really best judged by you, Mr. Hathcott, and the other people here that are taking the pictures, as well as those in the courtroom, better than I, because I'm a lawyer, and my viewpoint is probably not as close to that of the jurors as yours, because of the fact that I am a lawyer. And I would say that any kind of a judgment, if you want a value judgment, that value judgment is best made by someone other than I.
Let me ask it this way. Is this what you're trying to prove, that she's both a liar and an accomplice?
Well, you put me on the spot.
Unintentionally.
Because of the publicity order, but certainly I think that
I wouldn't lose any money on that kind of a bet, would I?
Well, let's say that I'm not a bookmaker.
Mr. Kanarek, are you satisfied with the way your cross-examination is proceeding?
Well, as I say, my
Just
answer,
in general characterization.
Well, my answer must be the same as that I gave Mr. Hathcott. Actually, my subjective satisfaction,
yes,
whether I'm happy or unhappy, is completely irrelevant. The important thing is, what does the jury think? And as I say, people other than lawyers can gauge better.
How did you assess Mrs. Kasabian's reaction to some of your questions, just on a human basis?
Well, regrettably, I can't answer that because of the publicity order. I would welcome being able to answer it, and what I've said before, and I think we have a due process, a very legal, constitutional way of changing the publicity order, and that is the people that are here assembled have some very competent, well-paid lawyers. And if they're unhappy with the publicity order, all that they have to do is get their lawyers down here to court, and I'm sure that Judge Older will listen to their arguments, read their briefs, and perhaps, since the jury is sequestered, Judge Older might well change the publicity order, because some lawyer that's a
Well, I think in regard to this immunity, in regard to a witness's relationship with the district attorney, one must bear in mind the Mary Bruner situation. And I think that's running through Mrs. Kasabian's mind. Her answers must meet and match the approval of the district attorney, else her immunity is somewhat in question. She has not been granted immunity yet, and the district attorney must petition the court for her immunity. And presumably, if her answers aren't what they anticipate, they will not petition the court for immunity.
You're not suggesting the district attorney's office has made up this fantasy, as you put it, and put it in her mouth?
I'm not suggesting that the district attorney's office made up the fantasy. No, I'm not suggesting that. At best, I'm suggesting that Linda Kasabian made this up, this fantasy, and communicated it to the district attorney's office, and the district attorney's office, in more or less good faith, is advancing it as their central theory of the case.